it's there. All right, yes, so great. We are on the live now, and I'm about to start presentations, the resumes, okay? And then start this great panel with great cartel busters. So good afternoon or good morning, depending on where you are watching us today. And it's a great pleasure that I start this panel on remediating cartels on behalf of IBCI, Third International Conference. And I would like to start presenting our speakers through Miss Cristiane Alkimin. She has a huge resume, a very beautiful biography, but I will try to summarize it. She's now the Secretary of State for Economic Affairs in the state of Goiás. Cristiane she's also a former commissioner at our antitrust agency, ADEPAR, and will bring us very insightful ideas on how Brazil stands on fighting cartels. We have also Professor Helene, is that right? Helene Andersson from the Stockhom University. Helene is Associate Professor in European Law at this university. And we also have here Professor Athayde. She's professor at UNB, and she teaches corporate law and economic and competition law, right? And also in another university, IDP. She holds a PhD in commercial law from the São Paulo University. And we have Dr. Marcio Schusterschitz, is that right? Dr. Marcio is a very true cartel buster. He's a federal prosecutor with an extensive experience in fighting cartels and conspiracies and the like. And Dr. Marcio will give us like a practical glance about how to do it. So with no more words to say, I start giving the word to our Secretary of State, Cristiane Alkimin. Please.
Thank you very much. First of all, I would like to give a special thanks to Mr. Vinicius Klein, extraordinary lawyer, for his very kind invitation. This is definitely a pleasure to be here, having the unique opportunity to share some of my very particular views, and I bet you know that, to minimize the existence of cartels in Brazil. On his behalf, I would like to extend my greetings to all of our remote audience who are here today in this remote auditorium, I would say. Secondly, I would like to thank the Brazilian Institute for Competition and Innovation, IBCI, not only for hosting this extremely interesting conference, but also to promoting essential discussions like this one in the field of competition and innovation. The IBC one was created in 2012, I understand, and is getting stronger year by year. Count on me, Edu and Ju, to make this institution one of the greatest in Brazil. Thirdly, it is such a bliss to be moderated by one of the founders of the IBCI, Mr. Eduardo Gaban, who is not only a good friend, but who is also married to the head of the Consumer Secretariat at the Ministry of Justice, another very competent lawyer, and also a very good friend. And it's also a bliss to have Professor Amanda today here, a very careful professional, and with plenty of extremely good ideas and thoughts. I think this is the first time we are having this opportunity to share a panel together, which makes me truly happy. Fourthly, I would like to express my happiness to have as a debater, Mr. Marcio something. I'm Marcio. I can't pronounce your last name, even having Schmidt on my own name, so I'm sorry. But seriously, I have to say that in my total admiration for the federal prosecutors that grew exponentially during my 4 years of CADE, since I got the chance to work very close with some of them and to see their professionalism, the serious work they all do, the careful investigation they make, and the holistic way of analyzing the proof of anti-competitive conduct made me admire not only their jobs, but also their way of working. And I have to admit, they have all influenced me very much in some judged cases of mine. So I am very grateful to have had the chance to work closely with all of them. Last but not least, I would like to express that it's a notable honor to be sharing this panel with Professor Helene Andersson, this prominent academic from Stockhom University. Undoubtedly, it will be a great opportunity to get at least a glimpse of what the book Access and Cartel Cases Ensuring Effective Competition Law Enforcement is about. I am sure tomorrow we will all be extremely delighted to have listened to your speech today. I am definitely looking forward. In fact, Professor, I must say that remediating cartel has always struck me as a very important topic, especially because of its significance for Brazil. As I normally say, cartels are a very expensive issue to the Brazilian society. Expensive because our economy has been very unproductive for more than 20 years. And I am sure part of it comes from anti-competitive conduct such as cartel. Therefore, I want to promote, if we want to promote growth and development, we need to improve the Brazilians' productivity. And if we want to enhance the country's productivity, we need to focus on having strong institutions. And if we want to have those strong institutions, we must be alert to be effective as in our institutions, such as with CADE and with our regulatory agency. They must become more effective in their actions, in their effort, in their punishments, in financial sanctions, especially with cartels. Ergo, Professor, your book come in a very proper moment, I guess. It should be read not only by me, but for everyone, everybody who is working in the government, because it will be very helpful, not only for competition specialists, but even more so for policy makers like myself today, and like Amanda as well. Therefore, on behalf of all policymakers, I would like to thank you, Professor Helene, for sharing with us today your perspectives and thoughts. As I said, it is an honor to share my views with you today here. Before starting my remarks on how we could remediate cartels more efficiently, I would like to share some highlights of my 2 years of experience since I decided to accept Ronaldo Caiado's invitation to be a part of Goiás government, considering that the decision I've made was a surprise for a lot of people back then. So in fact, in 2018, I was accepted to a postdoc at Yale after CADE, and I declined this opportunity. Some friends thought I had lost my mind. They started asking me how I dared to give up on a peaceful and calm postdoc at Yale and plenty of money in my pocket if I become a consultant in that time. But in turn, I changed all of that to a crazy life here at Goiás, where I don't sleep properly. I work 24/7, and I have 2 bodyguards all day long. And my answer is, I want to be here today, and I decided that time, 2 years ago, first because life is short and I am getting old and I need to do something to aggregate value as a public employee to my society now. This is my real reward in life, especially because I had a scholarship paid by the Brazilian government to do my master and my doctorate at FGV. I definitely want to sow good seeds now, so my kids, my grandsons, and all the Brazilians, especially the most vulnerable ones, can enjoy a better life in the future. I prefer not to sit and watch and complain, but to work hard and to see the change. And also, because I want to change the status quo in Brazil, and changing the status quo in Goiás is just the beginning of this journey, I hope. This is the school I need, learning from how to deal with a whole bunch of real problems with political economic look to find the most efficient solutions. So I am experienced today. It is not only a postdoc in economics. It's a postdoc in economics, anthropology, sociology, law, interpersonal relations, political science, and so on. So join the two secretariats as one, finance and planning, as I have it today. I knew from the start that I have to think out of the box to find better solutions for common problems. But indeed, my friends had a point, because not a lot of problems would accept a challenge that, one, to lead with one of the four states that needed the most fiscal adjustment in Brazil. Second, to put up a fiscally broken state to pay at least its compulsory expenses in this first year. Third, to face more than 40 unions demanding claims that you cannot give them. And fourth, to address really, really scary social problems of sorts. So you might be asking, though, why is she bringing her Goiás experience to this debate? And I'm telling you, I'm bringing my actual experience today, because the fiscal bankruptcy of Goiás and of many other states is intrinsically related to the extremely low efficiency, or perhaps effectiveness, of most of Brazilian institutions, including CADE and its inefficiency to condemn cartels properly. So we all should be humble and more reflective about what is really going on outside Brasilia, where is the CADE's headquarters. It's not a beautiful picture at all. But let me tell you that although this experience has been hard and sometimes exhausting, it has been giving me the opportunity to have very good insights in understanding which public policies are bringing results and which are not. Among those policies that could improve, I must say, the cartel enforcement one is one of them. There are many others that need improvement, such as a poor energy regulation enforcement but as this theme of regulation is not the theme of this conference today, let's focus on antitrust issues. So certainly CADE is doing its best, but in the state's jurisdictions, and I'm sure this happens in the municipalities also, the normality concerning government purchases is to have cartels being formed. Thus, I understand that instead of denying facts, we should accept reality, or maybe understand it and address the problem. The questions we should be asking are, first, why are cartels such a widely common practice in Brazil still? Second, why are entrepreneurs not being discouraged by committing a crime like cartel? And third, why are they not afraid of CADE? And why is your book, Professor Helene, so important for Brazil? Because even though a certain public policy could address problems in one country, such as Sweden, and maybe not in another, such as Brazil, it is very suitable, crucial, and clever to learn from other experience as a meaning of instigating and inspiring public policy makers just like myself to find solutions for their own problems. So having said that, and having bounded the problem, I have here 3 messages that I would like to express. So first of all, and then please, Gaban, can you put the first slide that is my first slide, please. Brazil is at the first one. That's not the first one. The really first one. Yeah, go the first one. You're going to the back. So you need to go the first one. The first one, please. No, the first one.
Go back, please. Yes.
Yeah,
more.
You have to go back.
Do more.
The beginning is the beginning of the presentation. So okay. Brazil is at, so I'm going to show you now that Brazil is at an economic and social crisis. It's the beginning. That's not the beginning. I would like to put in the first one. That's the 5th one.
I will
well,
do it.
That's okay. Okay, thank you. So Brazil is that an economic and social crisis for years, especially since 2014, and even more so in 2020, year that the government spending with health because of the pandemic was very expressive, as the cause is related to its very low productivity. The country needs a clear and straightforward set of public policies, and antitrust is one of them, of course. And we must have a long-term strategy to foster Brazil's productivity. So as you can see in my first slide, this one, yes, Brazil has grown not more than 3% in 10 years average since 1980. That's very poor. Secondly, this is because the productivity is extremely low. So the second one, please, the second slide, comparing middle income countries, especially China and its Latin American peers. If you look at this graph there are two graphs. The first one, the TFP, you just read as productivity. So the productivity in Brazil between 1960 and 2006, if you can see, it starts at one number and goes back to the same number. So we are back again to the same level as before. But look at the China's graph for the same period. They have grown 3 times more than before. So China started below Brazil with his productivity and now is above us. That's incredible graph, but we can show that graph in with our Latin American peers. The other one is it's our income distribution in our country is one of the worst ones in the world. The other chart I can show you, the other chart, please, I can show you that the cost for entrepreneur to produce are extremely high. The next one, please, Gaban. As you can see there, the Brazilian tax burden is one of the biggest among the middle income countries. If you look at the number that is there, I don't know if you can see, it's around 36.3. This number is the second one if you look at the other side. That's incredible. So we have our cost for our entrepreneur are too high here. The other problem Brazil is facing is that Brazilian federal government, the majority of the 27 states and the 5,500 municipalities are fiscally broken. So they cannot offer the population proper goods and services such as public security, education, healthcare, and sanitation. The other graph, please, it will show us that the nominal deficit in 2020 will be around 17% of the GDP. That's incredible, which means that our public debt this year will be something very close to 100%. That's incredible. If you look at this graph, in 2006, we started in a percentage of 55%. So we had a spectacular increase. Fact that resulting that Brazil's risk, that is the other slide, please, has enlarged too much. Okay, so in 2020, our risk, that's why our dollar is so devalued. And therefore, if you see to the other slide, please, the economists cover, as we can see, we can observe that the world perception, the other slide of the economist covers, please, yes. If you look at, there are two covers of Brazil. One in November of 2009, and the other one in September of 2013. And if you look at that, we can observe the world's perception that was going on to Brazil and what is going on right now. So if in 2009 people thought Brazil would take off, since 2013 the foreign investment started to go away, especially after 2015 when Brazil lost its investment grade. So in the next slide, please, and that's the only one till I finish my presentation. So, and I will stay here. So if you look at this graph, the GDP in the second quarter of 2019 was at the same level of 7 years ago in 2012. And it's almost 5% less than when we started our recession. That was in the first quarter of 2014. And nowadays, it's even worse. So in sum, and that's my first message, we are in an unsustainable situation for a middle-income country such as Brazil. Therefore, Brazil is urging for sustainable growth, development, and social justice. That's my message number one. My message number two, and then I'm going to relate with the topic of what we're here today. In order to attain growth, development, and social justice, the country must focus on having strong institutions, as Acemoglu and Robinson argue on their book called Why Nations Fail. So surely CADE, that was created in 1962, has been improving its effectiveness over the years, at least since 1994 with the first law, and especially since 2012 with the second law. Definitely, CADE is one of our most amazing institutions in the country, have deservedly won several awards over the past years as a consequence of its incredible effort to improve its own productivity year by year. So truly, CADE has been receiving awards since 2015 every year, and sometimes more than one award. For example, CADE got 4 stars at the Global Competition Review ranking since 2015, and we are still in this 4 stars, and we're still earning and getting some awards from the Global Competition Review. Also, we got awards from the International Competition Network from the World Bank, and many others reward national level. You can look at some details of those awards in CADE's website. So I invite everyone here to look at very close, because there are a lot of awards. So therefore, CADE is for sure, it's a very honorable antitrust administrative tribunal, and this is not being discussed here. The main point I would like to address is the point that I've always addressed, and I always came with the same point over and over again. But nowadays, with much more certain than before, because of the situation I am right now. So is that, albeit the words CADE got, there is still a margin for improvements if CADE wants to help Brazil become more productive. So in my particular view, and this is not exactly what maybe people think, but in my particular view, what is lacking is the understanding the real and final objective of having strong institutions. We need strong institutions to help the country to grow more and in a more sustainable way. We need to have strong institutions as an instrument to achieve a bigger goal. And I am sure one way to grow healthier is eliminating cartels. So we need to eliminate cartels. And if the evidence we have right now in Brazil is that it is not growing, so we need to change. So we need to have a close look to understand what is going on with our institutions, not only CADE, but the regulatory agents, for example. Something smells wrong. So why is wrong? What is wrong? And the wrong, I mean, effective. Why are institutions not being so effective? In fact, cartel is bad for the society because cartel is bad for the productivity and consequently for countries' growth and development. So I'm making the link of growth, development, and the enforcement of cartel. Cartel is not a desirable action by entrepreneurs. Ergo, cartel should be hardly condemned by governments, I guess. So my point is, based not only my antitrust experience, neither in the Ministry of Economics right now or CADE, but my experience nowadays in Goiás. Entrepreneurs are not afraid of making cartels in Brazil. They are not afraid of CADE as Google and Microsoft are with regards to the European Commission or DOJ. The consequence in turn is that not only CADE, but CADE also, because of that, the real contribution to enhance Brazil's productivity, it's not very high. And the question is, why is the reason for CADE's ineffectiveness enforcement? I have always been argued that it's because the fines imposed by CADE are lower than they should be. So the criminals will still do their crimes. They won't stop. And I think Gary Becker, former U Chicago professor and 92 Nobel Prize, would agree with me if he could have had the chance to examine some of the Brazilian cartel cases. It is unquestionable that cartels or crimes should be punished with fines bigger than its damage, not lower. And we know that private damage fines in Brazil is far away to complement, as they should, the public damage fines. Therefore, there are no balance and no proportionality. Thus, we have to count on CADE's action to minimize cartels being formed. For Gary Becker and also for me, the most important aspect for determining the effectiveness of an antitrust agency is to perceived by the society CADE's strong enforcement. That is the real dissuasive signaling for not committing the crime. The third cartel should be CADE's main objective, and it is as a sense, but the effectiveness, it's not there, in my view. Hence, as I have said here, CADE should apply severe penalties to economic agents, proportional to its damage, as it happens in the US, Germany, France, UK, countries that are 5 stars ranking from ICN. I have had always defended in my votes while I was a commissioner at CADE, the fines imposed by the tribunal expressed in the Article 37 have at least 4 problems, in my personal view. And that results in a weak effectiveness of CADE as the Brazilian antitrust institution. Indeed, fines are fixed not related to damage caused in the economy, but to an exogenous rules. And these exogenous rules takes into account, first, the gross income of the firms in only 1 year, regardless of the duration of the cartel. And normally cartel is formed for not less than 5 years. With them, then you get this number, and then CADE multiply it by a chosen percentage between 12 and 18%. The average is 15%. Although it could fit until 20%, and although the international studies indicates that John Connor and UCDE studies indicates that 25% of the cartel average overprice. So, and they choose this percentage based on Article 45. And the gross income should be related to the relevant market. That's an antitrust proper definition. Instead of it, in Brazil, was created a strange definition called ramo de atividade, under which we can fit a lot of different interpretations. And the last one, the 4th problem, I think, is that the money opportunity cost adjustment in time does not use the correct opportunity cost of the money, which is the nominal interest rate with compounded interest. Here in Brazil, we put simple interest. So with these 4 factors, those reduce a lot the number or the value of the fine that should be applied. Moreover, it is not only fining cartels improperly the problem of CADE's ineffectiveness for me. The leniency, the program is very good, but the agreements program, the TCC, in my point of view, have some problems. and it's resulting a great number of legal uncertainty items to be discussed. And when I was in CADE, I had a lot of discussions about them. So the agreements, for example, not only incur in extremely soft fines normally, but the way CADE calculates them has a lot of flexibility in its understanding, not being transparent or not being predicted. So in one hand, leniency in TCC programs should be attractive, having transparent and predicted rules. But for me, it's not the case. And I showed that in the many cases I voted there in CADE. On the other hand, fines cannot be too soft. Otherwise, CADE is rewarding the cartelists. That is what happened, for example, in the car wash cartel cases. The agreements ratified by CADE were, for me, a father-to-son Christmas present, showing that cartel is a great form to earn money in Brazil. Hence, for the reason expressed above, the cartel fines are usually less than the money collected by performing the anti-competitive conduct. So the fine is neither dissuasive nor educative, nor the TCC programs. Ergo, CADE needs to establish fines that cover at least the present value amount of the economic damage that has been caused by the cartelist, considering these opportunity costs. Otherwise, fining will always be inadequate and non-dissuasive. TCC programs, in turn, must have objectives rules, and fines agreed must be fixed, taking the damage into consideration, and the negotiations need to be only in terms of the discount you're gonna do it, because you're doing the TCC agreement. So I must highlight here that until now, the majority of the tribunal do not have, they don't want to address this problem because they do not think this is a problem. So we disagreed in this manner. I think it's a problem. So that's why I'm repeating here, and I'm using this opportunity to say once again, and based in my story here in Goiás, that I think I was right back before, and that's my perception nowadays. We need to improve. In other words, entrepreneurs and businessmen have to fear CADE sanctions. They have to respect CADE as pro-market institution, not a pro-business one, as Luigi Zingales from U Chicago taught us. And the third and last message, and then I finish, I was able to reinforce my opinion, as I said before, about what I have just said, because I can see clearly now, as a state secretary, the damage caused by cartels to states, as their fiscal crisis have also to do with the overprice they have been paying for years. Just to share here, when we started our mandate here in January 2019, we cut 20 to 30% of all contracts. And the contractors wanted to continue, some of them, but most of them wanted to continue offering the good and service to the new government with this reduced price. That was a warning that cartels were made here, and wasn't just for 15%, as CADE think it is, and for sure not for 1 year. Not for 1 year. So just for you to understand how the life is in the state level, let me tell you a short story that happened with me last year that shows the level of shameless of some entrepreneurs. One day I was working as usual, and a guy came to my office to claim that the Treasury of Goiás was indebted with him. And this was in 2019. I asked for his documents, and I realized that they weren't with his name or his firm's name. At this time, I asked him to clarify the situation and explaining why he was there and on behalf of another person, And he said that, I am here because I'm on behalf on my best friend. I said, best friend? And so it turns out that his best friend was actually his competitor that won the bid. And I think I might have made a surprise face when I noticed that, because he made a surprise face of my surprise face. So even though I was speechless, I asked him if he could explain the reasons his competitor friend was not there claiming for his money. And he said because his competitor friend trusted him completely. So the bottom line is, they did a cartel and he was there to claim for his part of the total amount. So this scene was remarkable for me. So if before I had a tiny little doubt about overprices were until 20%, after that, and after my experience here, I know that the overprice it's much bigger, 40%, 50% maybe. Consequently, I become much more skeptical about this CADE's understanding until now. So my conclusion, and that's my messages here that it's in this slide, in summary, I come here with 3 messages. First one, Brazil's lack of growth has mainly to do with this low productivity. Second one, the increased productivity. To increase Brazilians' productivity, Brazil has to focus on its institutions, making them stronger, more credible, thus more effective. CADE in particular does not have dissuasive fines, as I think. And my third message is that my belief in the fact that CADE's fines are improperly became more evident after becoming the Goiás Finance and Planning State Secretary. So indeed, a fine to have to punish a crime properly, as Gary Becker argues, to be dissuasive. If this was the case, we wouldn't be observing so many cartel cases in the state level. And if we want to eliminate cartels, we should foster growth, development, and productivity. This is the final objective, to foster growth, development, and productivity. So having strong institutions as CADE is just an instrument. Thus, CADE, to be effective and dissuasive, needs to establish stronger law enforcement in Brazil by enhancing its punishment. That's my thing. I know that I think differently of the CADE's tribunal before and this one, but that's my honest opinion about that. So I'm very thankful for this opportunity to be here. Thank you, Vinicius, again for the invitation. And it was an honor to be here today sharing my views with Professor Helene, Mr. Eduardo Gaban, Ms. Amanda, and Mr. Marcio. It was a very pleasant moment. Thank you very much.
I thank you, Cristiane. It was a fantastic presentation. I wouldn't say that nowadays the tribunal diverts that much to your opinion. I think they are changing their mind, but let's see.
But they're not voting.
I must confess. Let's see. And I guess they will change. They will change soon.
Well, let's see.
Later.
Now I have a lot of examples here to show.
Yeah. But Professor Helene, do you want some help with your presentation?
Yeah, perhaps I'll try to. Can I share the screen?
Yeah.
I'll try to do that.
Okay. All right. Yeah. So the word's yours.
Works. Perfect. And then I'll just try to get the. Okay. Is it okay if I start? Okay. So first of all, I would like to express my gratitude for having been invited to this conference to share the panel with such distinguished speakers, and having heard the State Secretary Cristiane Smith discuss the situation in Brazil has been really interesting. Usually when I discuss cartels and these issues, I have an audience and a panel with European speakers and a European audience, and we all share the same experience and the same perspective, and therefore I think it's really I'm really grateful for being here today and to get another perspective and share other experiences. But unfortunately, I realize that much of the problems that we are facing in the EU seems to be something that you are also facing in Brazil. But hopefully this will be a possibility for us to discuss possible solutions to any experienced problem. So this is what I'm going to talk about today. And usually, as I said, the audience is European and have an understanding of the European competition law enforcement system. And I don't know if perhaps you're experts, but if not, I'm just going to start off by briefly discussing and presenting the enforcement system in the EU, how it works. And then I'm going to move on to one part of the enforcement system, which is the leniency program in the EU and its role in the EU cartel enforcement system. And recently, there has been an increased focus on private enforcement of the EU competition rules, and I will present that. And this introduction of a new feature into the EU competition law enforcement system has actually tilted the balance, creating a situation which is not really unproblematic, I would say. So I will discuss that and also end by discussing some possible solutions. And here I would like to invite you all to come with some other solutions that might be. Well, as for the EU competition law system, the European Union is based on a number of treaties. One of these treaties is the Treaty on the Functioning of the European Union. And two articles in this treaty, Article 101 and Article 102, are the antitrust provisions. Article 101 of the TFEU prohibits restrictive practices, that is horizontal agreements such as cartels, but also vertical restraints, distribution agreements containing anti-competitive clauses and so on. And then, of course, as you are perhaps very familiar with, we have Article 102 prohibiting abuse of dominance. So these are the two main prohibitions. And as for their enforcement, the enforcement system for nearly half a century actually was very centralized. So it was the European Commission in Brussels that had a monopoly, you would say, on enforcing the EU competition rules, the prohibitions on restrictive practices and abuse of dominance. The member states of the European Union had some powers, but they were quite limited, I would say. So in practice, it was the European Commission that actually enforced the rules. But then things changed. In 2004, the enforcement of the EU competition rules was decentralized. So today, alongside the European Commission, all member states and their national competition authorities have the power to enforce the prohibitions in the treaty. So today we don't have one competition authority, we have 28 competition authorities enforcing the EU competition rules. And I would say that although the big cases are handled by the European Commission, if you look at the number of cases each year where a decision is taken concerning Article 101 or Article 102, a great majority of these decisions are taken by national competition authorities. So there has been a shift in the enforcement system. And this means that if, let's say we have a cartel where we have participants from a number of EU member states and the cartel is affecting all these member states, in theory, each of these Swedish, the German Bundeskartellamt, the Czech competition authority, the Polish, the Spanish one, could pursue this cartel in parallel. So we could have 5 different cases and 5 different infringement decisions and sanctions imposed on one and the same cartel. In practice, however, if we have an infringement affecting more than 3 member states, it will be the European Commission that goes after and pursues the cartel. So that's why the bigger cases are handled by the European Commission. As State Secretary Cristiane discussed so eloquently, cartels are harmful to the economy. We have the overcharges, which can be substantial, and of course they should be pursued for this reason. But if we have the European Union perspective, we also have another rationale or motivation for pursuing cartels. And that is the fact that the European Union is a union between member states that wish to eliminate any barriers to trade. The union should have an internal market where goods, services, capital, and labor can move freely without any borders. And if the member states are obligated to eliminate any barriers to trade and companies can erect the same barriers, well, that would go against the whole purpose of the European Union. So cartel enforcement, the EU, is not just to ensure consumer welfare, it's also to ensure the whole idea of the European Union, really. And as Cristiane has already touched upon, in order for companies to decide not to engage in cartel activity, which could be really lucrative, they must at least think that if they engage in cartel activity, they might actually be caught. And if they are caught, well, then the consequences are likely to be grave. It should be costly. You should not earn more money from engaging in cartel activity than the fines that you might have to pay if you are caught. So detection and deterrence is really quite crucial to an effective competition law enforcement. And as for deterrence and the sanctions, the consequences of cartel activity in the EU, cartel members may have to pay fines to the European Commission. The Commission has no other powers in that respect. And these fines could go up to 10% of the annual turnover. And this is the annual turnover not only of the company infringing the competition rules, but the entire company group. And then, of course, we have sanctions such as nullity and structural remedies, but they are not really applied when it comes to cartel cases. So fines is what companies fear if they are busted by the European Commission. But as I said, national competition authorities do also apply Articles 101 and 102. And if they do that, it is the national sanctions that will apply. So if the French competition authority imposes an infringement decision on a number of cartel companies, it will have to use the tools in its own toolbox. And up until recently, or actually up until February next year, these sanctions have varied quite a lot. So in some member states, they have been really tough. In other member states, well, not so tough. So the risks involved with cartel activity in the European Union has varied between member states. But now we have legislation in place which will take effect from February next year, harmonizing the sanctioning system and the investigatory tools granted to the national competition authorities. Well, then, as for detection, we know that cartels, they are secret by nature, and this means that they can be hard to detect. And here, the Commission actually glanced overseas in the 1990s and decided to copy the US system and introduce a leniency program in 1996. And this system, it has changed a bit over the years, but the Commission has come to rely heavily on leniency applications. I think the decisions taken during the period 2011 to 2015, in those cases, 91% of the cases originated from a leniency application. So as regards the EU competition law enforcement system, leniency has been a very important tool. And it has worked well, I would say. The Commission has busted a number of cartels over the last decades. But then something has happened. While leniency may have seemed like a good idea a few years ago, companies are now not feeling as certain about this as they used to be. And the reason for this is the fear of having to pay damages. Up until a few years ago, the EU enforcement system was centralized in the sense that it was not just the Commission as the public enforcer of the EU competition rules, as opposed to now the decentralized system where national competition authorities also have the power. It was also centralized being just a public enforcement system. The private enforcement system was very weak, I would say non-existent. So it was the Commission actually that enforced the competition rules, and the Commission alone. The Commission, during my talk here, I'm talking about the Commission as the enforcer, as the guardian of the treaties, but the Commission has the European Commission has a number of roles, you should know. It's not just an enforcer, the Commission also has legislative powers. Oops. Oh, what happened? I had a slide there, I thought, but no. And that is that the Commission is the institution, the EU institution that initiates any legislative action. So if we need to have some new legislation in the EU, it has to come from the Commission. And then we have the Parliament and the Council who actually adopts the legislation, but any initiative has to come from the Commission. Yes, and then, sorry, the private enforcement. While the Commission used to be the enforcer of the competition rules, things have changed, and it all started, the ball set in motion 2 decades ago, when we had a case before the European Court of Justice called Courage, where actually it was a British pub owner who sued a brewery. They had an agreement which was anti-competitive, this distribution agreement between the pub owner and the brewery. And apparently it was not really to the pub owner's advantage because he was suffering loss. So he sued the brewery. But under UK legislation at the time, you could not sue for damages if you were yourself party to an unlawful agreement. And the UK court wanted to know whether this was in line with EU legislation. So they sent a question, which you can do, to the EU Court of Justice. And the court said, well, this is not okay, because anyone who has been harmed by an infringement on the antitrust rules must be able to claim compensation for that harm. And this ruling was followed just a few years after by a ruling called Manfredi, where the court declared not only that you should be able to claim damages, you should also be awarded damages for any loss suffered due to competition law infringement. And such compensation should be compensation in full. That is compensation for actual loss, loss of profit, and interest. No punitive damages. That you should know. In the EU, and this still holds, you're not to award any punitive damages. So it's just compensation for the loss you have suffered. And then here comes the slide that I was discussing earlier. The Commission has the power to initiate any legislative proposals. So here, with these 2 rulings from the Court of Justice, it was thinking of whether it was actually time to introduce legislation on private enforcement as well. And the Commission carried out a study in the EU member states on the possibilities to get damages for loss suffered, and reported that the EU member states were in a state of total underdevelopment. In practically no one member state in the Union could you actually receive any compensation for loss suffered due to cartel activity. So with the two rulings from the court, the Commission now saw itself obligated to actually initiate legislation in the area. And a decade later, in 2014, we got legislation. We now have a directive on antitrust damages actions, and it has been transposed into national legislation 4 years ago. And I would say that this law is a game changer in EU competition and cartel enforcement, definitely. While only 10 years ago, no company engaging in cartel activity feared having to pay any damages in the EU. The situation is now completely different. One of the biggest cartel cases in recent years is the truck cartel, where a number of truck manufacturers were fined for having engaged in cartel activity. If you Google truck and cartel, you will find a number of web pages like this, where companies or individuals that have suffered loss due to the cartel can actually sell their claims to companies that will then pursue these cases against the truck manufacturers. And today we have a great number of ongoing cases, I would say, in Spain, in Germany, in the UK, in the Netherlands, in Finland. I mean, this is really a big thing. And companies now fear not only having to pay fines, they really fear having to pay damages. And of course, this is a good thing. I mean, companies now not only face a fear of having to pay fines, they also fear having to pay damages. But it's supposed to be a good thing, but it has actually proven a bit problematic. Because the EU enforcement system, which has been very much a public one, and where the Commission has relied heavily on its leniency program. It's been, 90% of the cases originates from leniency applications. And with a private enforcement system in place, companies might not really be that eager to apply for leniency any longer. And also, as State Secretary Cristiane discussed earlier, a well-functioning leniency program requires a number of factors. First of all, in order for me to even consider applying for leniency, I must fear that if I don't apply for leniency, the competition authority will come and get me. The competition authority will impose sanctions that are severe. It should hurt. I should fear that. So competition authorities need to be visible and aggressive in their enforcement activity, and the penalties for not abiding by the rules need to be severe. Otherwise, there's no point in applying for leniency. And then, as Cristiane discussed also, there needs to be transparency and predictability in the system. If I decide to apply for leniency, I should know what happens. What is the result if I apply for leniency? The rules should be transparent and predictable, so that I know that if I'm the first to apply for leniency, and if I follow the instructions in the whatever guidance or we have, then I should be certain that I will also receive immunity and not just perhaps a reduction in the fine. So the rules need to be transparent and predictable. And then also another factor which has proven to be very important is that the first one to report a cartel need to get a very heavy reduction, if not total immunity, in the fine. And it should only be the first one to get to total immunity. The second or the third one, if they also get total immunity, well, then why be the first one? Then you could just wait and see if someone else reports on the cartel, and then you could follow on and report yourself. So these there are other factors as well, but these are certain important factors. If we have a strong private enforcement system in place, as we are now getting in the EU, there are certain other factors that will influence my decision to apply for leniency or not. And as the rules are now framed in the EU, a company applying for leniency will have to provide a corporate statement admitting guilt. And while this statement may not be disclosed in a national court, so the physical document may not be disclosed, the information provided in the statement may actually be disclosed. And this is, of course, something you will have to take into account when you decide to file for leniency. So I have to admit guilt, and the Commission's decision will describe my participation in the cartel, something which cartel victims might find useful when suing for damages. And then, as I will most likely not appeal the decision, I will be the first one bound by it, and also the first one that can be targeted by cartel victims. So the question is, as regards the EU competition system, whether the protection that is currently afforded to leniency applicants provide adequate safeguards necessary to maintain the attractiveness of the leniency program. And I would say much indicates that it's not. Since the introduction of the private enforcement system in the EU, the number of leniency application has dropped, as I understand it, dramatically. So the Commission has been who has been relying heavily on its leniency applications when it comes to cartel enforcement, does now not receive as many applications as it used to. Because a number of studies carried out show that practitioners, they consider that leniency, it's no longer means closure. Today, it's only the beginning, and you don't know what will happen. I mean, the damages you might have to pay may be 4 or 5 times larger than the fines. And this is, of course, something which might not make you as incentivized to file for leniency as you used to be. And of course, if the number of leniency applications go down, so will the risk of being detected. And the deterrent effect of the cartel enforcement system will also go down. So if there are no other equally efficient means of detection available to the Commission, I consider that it's important to keep the leniency program attractive. And by efficient, I mean that it's very handy for the Commission to get an application to be contacted by the leniency applicant, the cartelists themselves, and get all the information basically that it needs served by the leniency applicant. So it gets informed about cartels and also gets the information needed to pursue the cartel. And then, of course, you can ask yourself, well, as I said in the beginning, well, doesn't the damages themselves have a deterrent effect? Of course, as it is now, I think that many companies will think twice, knowing that they might have to pay a fine, and they also see all these cartel damages claims popping up everywhere in the EU. So in the short run, yes, but in the long run, we know that most damages claims are actually piggyback or follow-on claims. You need to have the public enforcement system working, an infringement decision, which can be the basis for a damages claim. So if the public enforcement becomes weaker, then we will have fewer damages claims or cases as well. So we will need to find something else if we want to let go of the leniency system. And there are, of course, this is my final slide, there are, of course, a number of possible solutions. We could introduce even tougher sanctions. In the EU, we have since 2016, we have new rules on insider dealing. So this is financial market regulation. And today, if you are engaged in market manipulation or insider dealing, you might, as a company, have to pay very high fines, but also the managers, the directors of the companies, the listed companies, may have to pay fines of 5 million euro. And this is nothing you can have. Are not allowed to have an insurance for this, so you will have to pay the money from your own pocket. And then, of course, there are also requirements from an EU directive that the member states should introduce criminal sanctions, prison sentences for managers and directors engaging in insider dealing and unlawful disclosure of inside information. So perhaps this is a possibility if we make the public enforcement system even stronger. And then also the European Commission has tried another tool, and that is to try to get employees to blow the whistle, to actually inform the Commission of any unlawful behavior going on in the company where they are working. And there is also legislation in place now to protect these whistleblowers from sanctions from their employers. And there's also, we could do as in the UK and in Korea, this is just a suggestion, where you actually pay whistleblowers. They get remuneration for blowing the whistle on their employers. And then there is, I would say, perhaps not a final, but an additional solution to this. And that might be to extend the leniency system. As it is now, you will only get leniency from fines. But what about extending leniency to also cover damages claims? So that the first company reporting to the Commission will not only get immunity from fines, it will also get immunity from any damages. And in Xchange, it could provide cartel victims with all the information in its possession. I guess that might be one way of dealing with this problem. Thank you.
Thank you very much, Helene. It was very informative, I would say, presentation. And as I expected, dialogues a lot with the first presentation.
Yes.
And abusing of my moderator position, I will make some comments before taking the words to Professor Amanda. So I question myself. You know, we have a leniency program in Brazil. I mean, we will complete soon 2 decades, right? And I doubt we raised the detection of cartels in the country. I doubt, and I bet we are quite low than the average showed in the O'Connor's research about, he says, like 33% of the cartels are detected, you know. I don't know other empirical research similar to Professor Connors, but, you know, I think he is quite right. And we have in the country a lot less than 30% of detection, right? So maybe we should think of going to another level and thinking of another way to picking up finding these secret agreements and combating them, right? Maybe imposing damages to the leniency a lot lower than the others. Maybe it's a nice way, right? Because what happens if we have a leniency, a strong leniency program, but the other, the co-authors receive a very tiny fine?
Yeah. Well, then there's no point in applying for leniency. And
yes,
yeah, that's my point.
Of the day, it was a big mistake applying for leniency, right?
Yeah, yes.
Chris think this way.
Yeah, exactly.
So, but stopping my abusive behavior, I pass the word to Amanda, and I only ask if you may, Professor Helene, stop sharing the screen, please.
Yes.
Taking the opportunity before making my presentation about the leniency topic, I cannot stand myself without speaking anything, because this is my academic topic for some years and some practice topic as well. I would respectfully disagree on some points that regard the at some point the lack of efficiency of the leniency program. I think it is a strong tool by itself that has to be enforced together with other tools. So the fact that the leniency program has some consequences, for example, the private enforcement, or for example, the penalties applied for other individuals not covered by the leniency agreement, is not a problem on the leniency program as well as by itself. It's a problem on other topics that are a consequence of the leniency agreement. So those might be the ones that might be the focus of our attention. Since we have, for example, some ideas for extension of leniency, extension for civil liability, or some tools to enforce more the competition sanctions on the individuals that are not the ones that collaborate with the authorities. So my presentation today may give a light on that sense as well, hopefully, because I will talk about alternative sanctions that are not those generally applied only on monetary sanctions. So having that parenthesis done, I would like to thank IBCI for the invitation to join this event. And on behalf of Eduardo, Gaban, Vinicius Klein, and Juliana Dominguez, which is a dear, Juliana is a dear friend and a co-founder of our network, so-called Women in Antitrust. So it's a great panel to be, a great honor to be in this panel alongside with two other women as well as two other he for she guys, which are Marcio and Eduardo. So it's a very great opportunity to share some thoughts about this thrilling topic alongside with this panel, Cristiane, Alkimin, and Marcio Schusterschitz. I had the honor to work with during the years I work as the head of the leniency unit at CAGI, as well as Helene Andersson from Stockhom University, which I learned a lot now with you. So I would also like to thank the audience for the time to hear us in a time full of webinars. And as a former representative of CAGI, I would like to point out since the beginning of this presentation that the thoughts presented here are my own. As a researcher and as a professor of law in the University of Brasilia. So our topic today is remediating cartels. So the question to be answered may be, what are the tools that the competition authority may use to remediate those cartels? So besides some possible answers as criminal sanctions is important, yes, I know that, and it's a fact in Brazil because pursuant to our Article 4 of the law 8137 provides that cartel is punishable by imprisonment from 2 to 5 years. And the other possible answer how to remediate cartels, it would be private enforcement, which is also provided by our law in our Article 47 of Law 12529, which brings some questions as Professor Helene just mentioned. But my focus today will be on the administrative sanctions that are provided by the Brazilian authority, by the Brazilian antitrust law and enforced by the Brazilian antitrust authority, and specifically on those of non-pecuniary nature. So even if an offense is subject to criminal, civil, and administrative sanctions. If companies and their executives are not adequately deterred and informed about the punitive power of the public authorities, they may understand that the sanctions are offset by the potential rewards of the infringement. That was what Professor Helene and Cristiane Alkimin were just mentioning. Hence, it is relevant for the competition authority to have decisions, to have prior convictions, and effective sanctions, which, in addition to punishing those offenders in a given conduct, in a concrete case, may send a clear message to the market. We do not admit this type of conduct and we will punish it hardly. In this context, I think it's important to bring some light to the discussion about the importance of non-pecuniary, non-monetary sanctions. If the penalties are only money related, it is possible that the companies involved, they will pay the fine for the executives, making it worthwhile incurring the risks of the cartel practice. So when the penalties concern only the pocket, the individuals who are those who effectively conduct the practice, they become less afraid of the implementation of this cartel. And,
I'm sorry.
And on the company's perspective, it would also be possible for the company to imply the value of the fine finally applied by the competition authority on the prices of its products and services, which will consequently doubly harm the consumers. So having that in mind, what are the sanctions that are provided by the Brazilian competition law? So CADE recognized in its guidelines for cartel fines that the main penalty imposed is the fine. This is a quote. But it's important to stress that Article 38 of our competition law provides several other penalties, which may be imposed alone or cumulatively with the fine when required by the seriousness of the facts or the general public interest. So in practice, I had the sense that those alternative sanctions were not used frequently by CADE. So I decided as a professor, as a researcher, to conduct an empirical analysis on that topic, which I will share to you right now, brand new, so spoiler alert to everybody. The consolidated result of the research will be published on the second edition of my book, which will be published next year, which is the Manual of Leniency Agreement in Brazil, Theory and Practice. But the outcome of this point, which I bring now to this presentation, will be in a short run published as well in English, hopefully with the collaboration of my academic student researcher, Gabriela Gurgel. So in order to test these research hypotheses, I asked for CADE and its Citizen Information Service the data of all the cases that CADE's tribunal decided between March 2012 and September 2020. And the data provided by CADE showed me that there were a total of 476 non-monetary penalties applied. This might seem a very high number of penalties, but I might stress that those penalties are considered individually, which means that the same legal entity or the same individual may have been sentenced to more than one penalty. Either that may be monetary or alternative non-monetary sanctions. So these may overrate this absolute number. That being said, out of this total of 476 non-pecuniary penalties, it is possible to observe some of the following situation. We have 86 sanctions which are related to the item 1 of Article 38, which refers to publication in the newspapers of the extract of the conviction. So this represents 17.4%. We have 65 sanctions related to item 1 of Article 38, which regards the ineligibility for official financing and for participating in biddings. So this represents 13.6%. We have 110 sanctions regarded to item 3 regarding registration of the wrongdoer in the National Registry for Consumer Protection. So this is 23.1%. We have a total number of 0 sanctions applied regarding to item 4A, referring to the recommendation of the respective public agencies to grant compulsory license on international property rights. We have, so this is 0% as a consequence, obviously. We have 139 sanctions which relate to item 4B, which refers to recommendation to public agencies so that the infringer is not granted installments in federal taxes or cancellation of tax incentives or public subsidies. So 29.2% related to that non-monetary sanction. We have only 6 cases related to item 5, which refers to the company divestiture, transfer, or corporate control, sale of access, or partial interruption of activity. So this represents only 1.2%. We have only 6 cases referring to item 6, regarding to the prohibition from carrying on trade on its own behalf or as a representative of legal entities. So this is a non-monetary sanction applied to the individual. So because it may not carry trade or act as a representative or of the legal entity for a period up to 5 years. So this has been done only in 1.6% of the cases. And finally, the last item, item 7, we have 65 sanctions regarding any other act or measure required to eliminate harmful effects of the economic order. So I noted, therefore, that despite this high number of non-pecuniary penalties applied, the enforcement of those non-monetary sanctions by CADE tends to be, in my point of view, in some way, just for the record. So the 3 most used sanctions, items 1, 3, and 4B, which jointly compute 67% of those cases. They reflect almost proceedings because they regard to publication of the conviction or mere recommendation to bodies, whether for entry or public register or for non-granting installments of federal taxes. In turn, the most severe non-monetary penalties, such as those related to structural remedies, company divestiture, transfer of corporate control, sale of assets, partial interruption of activity, and also the most severe sanction probably applied to the individual itself, which would be the prohibition to carry on trade or on behalf of a legal entity. they are only used on 2.8% of those cases. Furthermore, a potentially severe sanction, such as a compulsory license of intellectual property rights, although as a recommendation as provided by item 4A, has never been applied by CADE over all those 8 years. It also should note that 13.6% of those cases regard these broad penalty as any other act or measure required to eliminate harmful effects. I should note, however, that one of the monetary sanctions, a severe non-monetary sanction that is genuinely being applied by CADE, is the penalty for ineligibility for financial of official financing and for participating on biddings, because it represents 13.6% of those fines. And that might be a result of CADE's recent cases on fighting bid rigging cartels. So this brings some light to the data that we have about non-monetary sanctions in Brazil on my empirical research. I would like to take advantage of this opportunity as well to suggest 2 other research of Brazilian academics related to this topic. The first one is a graduation researcher called Barbara De Carli, which is also a member of our network, Women in Antitrust. And she conducted a research called Non-Monetary Sanctions in Violations Against Economic Order, an analysis of CADE jurisprudence under Law 12.529. And Barbara warns in her conclusions that only 22 cases could be considered as reasoned decisions by CADE, with considerations, grounds, or minimal conditions to justify the application of those non-pecuniary penalties. And the second one the second research I would like to bring some light is a master researcher called Renan Cruvinel. He published his article just yesterday. It was published today in CADE's review, a paper called Defining Optimal Sanctions for Anti-Competitive and Corrupt Practices, Punishment of Individuals Through Alternative Mechanisms. And it's interesting to see that Renan defends the use of alternative sanctions as a effective way to prevent recidivism, as well as to move the impact of those sanctions to the individuals themselves who ultimately perform this conduct. In this sense, the author analyzes specifically 3 types of those alternative sanctions, which would be the transfer of control, the prohibition of individuals from carry on trade, and the punishment that might be carried on of perceiving the corporate view of the legal entity. So, having all that in mind, my own empirical research and the 2 papers that I have just mentioned, I would like to go to my final remarks. So, criminal, civil, and monetary administrative sanctions may be already the target of many academic and concrete debates in Brazil. CADE has been very successful in condemning companies and individuals with high monetary fines, which frequently provides much press attention. However, the data, the outcome of these empirical research on non-monetary sanctions and the academic papers mentioned give a glimpse that those alternative sanctions are not yet or may not yet be adequately applied by CADE's tribunal. And they're not yet a hot topic on the academic discussions, either in Brazil and, I don't know, maybe abroad as well. So in my point of view, the focus of those researches on those alternative sanctions, they may provide a virtual positive effect on the competition agenda in general, since it may increase the incentives for self-report of the infringements by the legal entities and individuals. So instead of being afraid of the private enforcement subsequent to the leniency agreement and the cease and desist agreement mentioned by Professor Helene, they may be more afraid of the monetary sanctions combined with those strong alternative sanctions, which may then unbalance the fear of those wrongdoers in favor of the competition rules. So those are my remarks, and I thank you very much for sharing this panel with you.
Congratulations, Professor Amanda. It was a very informative presentation indeed, very nice. I think it's clear. I think it's a commonplace that no one believes in one single sanction rather than a package, right? So having this in mind, I pass the word, and you can do in Portuguese, okay, Marcio? Pode falar em português?
Can I just have just not to? I thought Amanda was a wonderful presentation, and gave me very insightful thoughts. And I'm just gonna tell you that there is something that maybe people can start, CADE can start using the number 8 here. If you try to prohibit the firms of using tax benefits, I'm sure that this will work. So just to make this observation, because I really enjoyed listening to Article 38, and I just put it here to look a little bit, and tax benefits, it's one of them that maybe can work. Maybe can work.
Ancillary penalties, I mean, sometimes, mainly in bid rigging cases or public procurement cases, the ancillary is much heavier than the fine itself. So
yes.
The ancillary penalty in antitrust law for bid rigging is heavier than the anti-corruption law prohibition. And CADE and anybody who enforces the antitrust law should rely more on this for including to accept to settle. Maybe this is an idea. But Marcio, você quer fazer uma outra pergunta, uma colocação à vontade, por favor.
Posso começar? Boa tarde a todos. Desculpa especialmente a professora Helene, que não está entendendo, mas peço desculpas a ela por estar falando em português. Gaban, por favor, se achar interessante passar algum ponto para ela em tradução, eu peço para você. Já começo te agradecendo, Vinícius, pelo convite, agradecendo a Cristiane, a Amanda e a Helene por comporem comigo esse painel. Eu fico por último, vou tentar ser breve, muito já foi dito, enquanto todas falavam. Eu fiz 20 observações, 20 ideias, eu anotei aqui no meu celular e queria trazer nessa pontuação, que eu acho que vai ajudar a conversa a ser breve, objetiva e seguir um pouco essa linguagem da internet. Imagino que muita gente já esteja cansada. Então, pegando um pouco do que foi falado, realmente o Brasil tem problemas econômicos profundos. Muitos desses problemas eles surgem da política e talvez do modelo social brasileiro, que eu falo talvez porque eu não sou sociólogo, então não quero indicar nenhum rigor. Esse é o primeiro ponto. O segundo ponto é que o cartel é uma parte menor, embora ela não desprezível, de toda essa problemática econômica no Brasil. Então, o primeiro ponto que eu queria sugerir, a primeira conclusão desses dois pontos, que provavelmente, ainda que o Brasil tenha sucesso no combate a cartéis, ele não necessariamente vai deixar de ser economia com os problemas que atualmente tem. No combate a cartéis, especificamente, o Brasil segue um modelo internacional. E esse modelo internacional, o centro dele é o acordo de leniência. Então, nós copiamos o modelo internacional, chegou depois no Brasil, e principalmente esse acordo de leniência, ele é a nossa chave de combate a cartéis. Esse modelo ele tem problemas tanto em geral nos países, nas jurisdições que usam o acordo de leniência, como problemas específicos aqui do Brasil. Então, o terceiro ponto é que se copiamos o modelo da leniência, e o quarto ponto é que a leniência é muito útil, muito importante, mas ela não é perfeita. Ela não é perfeita de modo geral, não apenas no Brasil, talvez por dois motivos principais. O primeiro é o custo de se beneficiar alguém que pode se aproveitar do cartel. Então, como o cartel é uma infração clandestina e ela só consegue vir, em geral, para o conhecimento do poder público pela notícia do próprio infrator, o poder público tem que aceitar um preço, assumir um preço muito grande, que é a impunidade a alguém que, no fundo, pode se aproveitar do cartel. A lógica disso não é só o combate àquele cartel, mas ao próprio sistema de combate a cartéis. E o segundo ponto que a professora Helene colocou também, mostrando que ocorre na União Europeia, a conciliação da multa administrativa ou da sanção administrativa com outros subsistemas sancionadores, o criminal e a responsabilidade civil. Lembrando que a União Europeia, por exemplo, ela não é uma autoridade criminal, ela não persegue em nome próprio nenhum delito. Então, o próprio modelo de defesa da concorrência na Europa tem essa dificuldade de encaixe também da persecução penal. Em particular, no Brasil, nós não temos, isso é uma opinião minha e talvez um pouco polêmica, objetivos muito claros para o sistema de defesa da concorrência. A União Europeia tem objetivos muito mais claros, talvez, do que os próprios americanos, porque o objetivo principal, e a defesa da concorrência vem já no próprio Tratado de Roma, é se conseguir, também por ferramentas de proteção da concorrência, a formação de um mercado comum. Tanto que na Europa, ao contrário do Brasil, um dos principais infratores no antitrust europeu são os próprios Estados nacionais com barreiras locais à competição interna, que é um modelo muito particular. No Brasil, nós não sabemos direito para que serve o nosso antitrust. Nós pegamos na prática o modelo americano de bem-estar do consumidor, mas escrevemos livros falando sobre política econômica, desenvolvimentismo. Então, existe uma certa ambiguidade, na minha opinião, nos nossos objetivos de todo esse sistema econômico. Além do mais, historicamente, o Brasil tem um modelo de proteção do agente econômico ineficiente. O Brasil protege a indústria ineficiente, isso vem desde o modelo de substituição de importações. Então, o Brasil não é tão assim à vontade com a ideia de eficiência dos seus próprios agentes econômicos. Existe um paradoxo, talvez, entre os objetivos do antitrust e a própria realidade econômica no Brasil. O Brasil também tem um problema particular de federalismo. Nós temos um órgão, uma autoridade antitrust federal, e nós temos problemas, por exemplo, de cartéis locais. O grande exemplo de cartel no Brasil é o cartel de posto de gasolina, que é um cartel local. A legislação é federal, então nós temos grandes dificuldades de transitar o assunto do antitrust, o cartel, inclusive, pelas diversas esferas da nossa federação. E, para finalizar, talvez mais do que qualquer país, nós temos um problema de instabilidade institucional muito grande. As regras do nosso jogo são pouco claras, elas demoram a ser definidas, e quando elas são definidas, nada garante que elas não vão mudar por uma mudança de interpretação dos tribunais ou por uma própria alteração legislativa. Dentro desse contexto, que eu coloquei como ponto 8, entrando na nossa lei antitrust, a nossa lei antitrust, ao contrário de outras leis da década de 90, seguindo a Constituição de 88, ela é muito ruim, muito fraca, e não por defeito, mas pelo próprio paradigma que ela seguiu, na ideia de diálogo de fontes. A nossa lei antitrust conversa pouco com institutos jurídicos fora do direito antitrust. Isso é particularmente importante no caso da responsabilidade civil. A responsabilidade civil tradicional, como pensada no direito civil, eu acho ela muito difícil de ser operacionalizada numa lesão a partir de cartéis, numa lesão decorrente de uma infração à defesa da concorrência. E um exemplo que eu vou dar é que o dano do cartel, de certa forma, pode ser entendido como meramente hipotético, porque você nunca pode falar que o preço do cartel deveria ter sido X, enquanto ele foi Y. Você não tem direito necessariamente a determinado preço. E o nosso sistema de responsabilidade civil é muito ruim de arbitrar dano que não seja o dano calculado, o dano em concreto. Passando para a parte criminal, esse é o 10º ponto que eu coloquei, é importante lembrar que o cartel é nosso, na prática, o único crime contra a ordem econômica. Então, quando nós falamos de autonomia de instâncias, colocar o direito penal como uma das instâncias que tem que ser levada em consideração é relevante, de modo geral, apenas para cartel. As infrações unilaterais, por exemplo, desde a reforma recente, na Lei 8137, todas elas foram descriminalizadas. Então, o Ministério Público, como o titular da ação penal, ele só entraria no jogo de defesa da concorrência precisamente no combate a cartéis. Aqui, a persecução penal também se aproveita em regra da leniência. De modo geral, a persecução penal de um cartel nasce também de um acordo de leniência que no direito penal vai funcionar como, no processo penal, vai funcionar como notícia-crime. E o ponto 12, que é interessante, que é um alerta interessante para se pensar, o direito penal ele tem desenvolvido recentemente um modelo negocial muito sofisticado. Então, no Brasil, o direito sancionador começou a trabalhar, tem o paradigma do negócio sancionador exatamente na leniência, mas o direito penal tem avançado em outros negócios sancionadores. Recentemente, o exemplo é o acordo de não persecução penal, quando o Ministério Público Federal, pela Procuradoria da República em São Paulo, fez o acordo com a Superintendência do CAD, o CAD não existia esse instituto, nós trabalhamos outros institutos negociais, e além dos institutos negociais em si, o direito penal cada vez mais é interessante, pelo que a Amanda falou, de se pensar em outras sanções, ele está trabalhando com ideais de justiça restaurativa, que é uma via muito interessante para se trabalhar a recomposição do cartel dentro de uma outra linguagem. A justiça restaurativa é interessante, esse é o ponto 3, porque o cartel, a gente fala de cartel, mas os cartéis são realidades heterogêneas. Os cartéis existem em diversas situações. É interessante se pensar no próprio contraste desse cartel que eu já falei, do posto de gasolina num bairro, com cartéis internacionais em que, muitas vezes, nenhuma das firmas tem sede ou filial no Brasil. O Brasil é apenas um recebedor do preço daqueles cartéis. Essa realidade heterogênea do cartel é o outro ponto, faz com que a leniência nem sempre funcione tão bem. Ninguém que combate cartéis em postos de gasolina espera iniciar o enfrentamento daquele cartel a partir de um programa de leniência. E, por outro lado, cartéis internacionais exigem não só um programa nacional funcional, mas exige todo um modelo de cooperação internacional. Você negocia internacionalmente cartéis. Isso é interessante porque um dos casos de arquivamento de inquéritos cujo objeto é cartel, que se faz aqui na Procuradoria da República em São Paulo, é exatamente aquelas firmas que estão totalmente no exterior. Porque a nossa conclusão é que a extraterritorialidade da lei administrativa e da lei criminal seguem princípios diferentes. Outro ponto interessante dentro dessa heterogeneidade dos cartéis é que muitos cartéis eles ocorrem em elos intermediários da cadeia econômica. Nós falamos sempre de bem-estar do consumidor, mas muitas vezes o cartel ele não está na venda final ao consumidor. Ele está em um elo intermediário da cadeia econômica e essa condição ela tende a aumentar a clandestinidade dos cartéis. Porque não só o acordo é clandestino, como muitas vezes os preços não são visíveis. elos intermediários das cadeias econômicas não trabalham necessariamente com preços de prateleira, trabalham, por exemplo, com orçamento e consulta, e muitas vezes sequer a autoridade de antitrust tem conhecimento dos preços que são praticados em dado mercado. Um outro ponto bastante interessante, voltando à área criminal, é que cartéis, especialmente no Brasil, podem estar conjugados com outros crimes. E daí nós temos uma discussão muito importante sobre o concurso de crimes. Seriam crimes beneficiados pela leniência também, como o artigo 87 fala, ou se, na verdade, seriam crimes em que o cartel seria apenas lateral a eles, como eu entendo que é o caso da própria corrupção. Dentro dessa lógica da corrupção, eu trago o 17º ponto, está quase acabando esses 20 pontos que eu quis trazer, que hoje o problema mais recente de combate a cartéis no Brasil é exatamente a confusão entre institutos antitruste com institutos anticorrupção, exatamente pela problemática do encaixe do cartel de licitações, onde se encaixa na institucionalidade brasileira, não só com relação aos órgãos, como a tipos sancionadores, o cartel de licitação. Outra questão de atualidade do problema dos cartéis é que nós também precisamos compreender como serão os cartéis do século XXI, em uma sociedade digital, não apenas em uma economia digital. Então, os cartéis, eles existem no ambiente digital, mesmo que a indústria cartelizada não seja uma indústria digital, porque a sociedade digital traz, por exemplo, possibilidade de precificação por inteligência artificial. Você vai estar num novo ambiente de formulação de preços, inclusive, eventualmente, dos próprios preços cartelizados. E esse contexto tecnológico é interessante porque, para o aplicador da lei, para o agente sancionador, ele coloca novos problemas para a prova e também para a cadeia de custódia da prova. Hoje, os órgãos que combatem cartéis têm que ter uma nova inteligência, não apenas na detecção do cartel, na identificação da prova, como na própria preservação da cadeia de custódia da prova. E um último ponto é o ponto do atraso, e aqui eu queria encerrar, que, como regra também no Brasil, a persecução dos cartéis ela convive com aquele nosso problema do tempo para a solução dos conflitos. Nós sabemos onde o combate a cartéis começa, mas é difícil saber quando ele termina. Muitas vezes as decisões, tanto administrativas quanto judiciais, surgem apenas muito depois no tempo, e com aquele problema da revisão judicial da administração pública. Nada impede que uma decisão do CAD seja contestada em juízo e o nosso relógio zere voltando a correr por mais um longo tempo. Me coloco à disposição, agradeço todo mundo de novo, peço mais uma vez desculpa por ter rompido aí o clima do inglês, mas eu não quis virar meme, eu já tinha avisado isso para o Gaban. Obrigado, boa tarde.
So, thank you very much, Marcio, for unfortunately, due to the tight time we have, Helene, I will not be able to summarize it in 2 words, because he got 20 points. So, but I would like to thank you all and to pass the word, if you promise me to take 10 seconds or so to final remarks, except from Marcio, because he had the word already, okay? So starting from Chris, Helene, and Amanda, and I thank you very much for this insightful and very clever panel. Thank you.
Well, first of all, I would like to thank once again, Mr. Vinicius for the invitation to participate in this panel. And it was an honor to be here today sharing my views with Professor Helene, Mr. Eduardo, Mr. Marcio, and Amanda, that gave me some very good ideas about Article 38. I think the prohibition, think about that, the prohibition of using tax benefits, maybe it will be a very, very clever measure, a non-pecuniary penalty, because at the end, it's a pecuniary penalty, will be. but it's not in the form of the law. So I think that's a very clever one to look at. And I also just make a comment of Marcio that the fourth revolution also scares me, because to get objective proof, evidence on cartels, I don't know how we're going to do it. And my experience in CAGI is that CAGI wants very objective evidence. And I think in this new world, if you stay in this mindset, I don't think we are gonna get so many cartels, because the cartels are much smarter than they used to be. We are not gonna get an email anymore. We are not gonna get a call anymore. So that scares me a little bit. So I think you got a point. And also the in Brazil, the antitrust institutions with the corruption institutions, I think we have to deal with it because this is a subject that it's okay, Eduardo. Okay, I'm sorry, I extended too much. Okay, bye. Thank you very much again.
Great. So again, also thank you for the invitation and the possibility to share my views and also get to hear your views on this. And I must say that although I thought that the problems we have in the EU are European problems, I realized that they may be global problems, that we are all struggling with the same problems. And I was very intrigued by the idea of having, alongside the pecuniary sanctions, having also non-pecuniary sanctions. But I think that if we do that, we need to be tough enforcers also of the non-pecuniary sanctions. You mentioned, Amanda, that you had, I think, 2.8% of the cases were directed disqualification. I may be wrong, but we also have this possibility in Sweden that you can actually get a trading prohibition as a manager or a director. You will not be able to pursue business for a number of years. And it is, if it's used, it's a very strong tool, I think. But 8.8% is actually a great number, because in Sweden, it has never been used. It's there, but it's not used. So then it's not really something that companies or managers fear. So we need to have tough sanctions, and we also need to enforce these rules and use the sanctions. Thank you.
I have 10 seconds, so I would like only to bring light again to those alternative sanctions as a old new trend, maybe, and to thank you all for joining this panel with me. It was a great honor to share that, to share some thoughts and to learn with you. Thank you.
Thank you very much.